Good afternoon. Thank you for joining us. I'm just going to turn my video on. Hello there. My name is Marie Redman and I am a member of the criminal team at Goldsmith Chambers. Very pleased to be introducing you to the first of the criminal team's webinars as part of our online webinar program. Today's talk is going to be about police station interviews during the pandemic. A few matters of housekeeping before we start. We can't see or hear any of you, so don't worry. Nobody can see what you're doing, what you're wearing, what you're drinking, and nobody can hear you either. But there is a question and answer tab at the bottom of the screen. If you have any questions whilst the talk is going on, please feel free to type them in there, and at the very end of the webinar we will try our best to answer them if there's time. The slides and a recording of this webinar will be made available in the next few days via the Chamber's website, and I understand you'll receive an email confirming that they are now available for you, so please don't feel that you need to email Chambers to chase them. You will get an email from us telling you that they are available. Just before we begin, the structure of the talk today. First of all, Hannah Gladwell is going to address you on the protocol that's been put in place to keep practitioners safe when providing representation at the police station, and she's going to raise some of the issues that have arisen for practitioners whilst attending, virtually or otherwise. And then after that, I'm going to be talking about the implications when there have been problems at the police station during this time, the implications at trial. It gives me great pleasure to introduce to you then Hannah Gladwell, who is my pupil. She is a third six pupil in Chambers. She's practicing both prosecution and defence, predominantly the Magistrates Court at the moment, but is starting to build up a Crown Court practice as well. Perhaps of interest to you in terms of this talk, she also has 2 years of experience as an accredited police station representative, so she does have some knowledge of the subject matter. Okay, Hannah, I'm going to hand over to you.
Hello everybody. As Marie said, I'm just going to briefly touch on some of the issues that I know have occurred from different solicitors that are attending police station. So first slide, I've talked about the national protocol. So as of April, a protocol came into place. It was created by several different bodies, and it really is in place just to try and protect everybody really that's attending custody. So not only detainees and police officers, but also, if appropriate, solicitors and legal representatives, appropriate adults and interpreters. Now, I've put a link there on the slide to the national protocol. I won't go through it in a huge amount of detail, as I'm sure you're all aware of it. But really, the main thing that's come out of this protocol is that it means that representatives no longer are required to attend a police station physically. And there are different measures in place now to try and help people in attending remotely. So whether that's over the telephone to give some advice or on a video. Now, there are a number of issues I know that have occurred from different people that are trying to use these facilities. I will try and touch on them as best as I can at the end of my speech. But like I said, and like Marie said, if there is any questions that do arise, do type them in the Q&A box. So I've put here on this slide really the main provisions I would say that you should be drawn attention to when looking at this national protocol and how it impacts others. So Section 58, clearly a detainee or a suspect has access to legal advice and they should be given that. And particularly in Code C, paragraph 6 of PACE, that includes the detainee's rights to communicate privately with a solicitor or a legal representative. Now, the reason I've put that in there is because it does say in that provision that a detainee can consult with a solicitor in person, in writing, or by telephone. So the reason I've highlighted that is the national protocol that's now in place that allows for remote attendees from representatives, whether that has a bearing or an impact on the detainee's right to legal advice. I would suggest in this current climate, no, and that we should be making use of facilities as best as we can. But it is certainly a consideration, especially if this matter then goes to trial. And I'm sure Marie will talk more about that later. Now, custody officers, we know that they have a duty of care to everybody that comes into their custody suites. Now, Code C paragraph 3.6 states that all custody officers are responsible to risk assess everybody that comes into custody. And if there are issues, then it's their duty of care to make sure that they're protecting those that will come into contact with that detainee. I've put paragraph 3.8a in because obviously if you need to attend physically at a police station for whatever reason, any information about that detainee that is associated with the risks shouldn't be withheld from you. So if you are experiencing concerns when you meet your client, then you have that code to rely on, and you can ask the custody officer for details about that risk assessment. They can't give it all to you, but they shouldn't withhold any information that could affect it. Now, the reason I've put in about voluntary interviews is I'm talking an awful lot about detainees, but of course we know that PACE does cover people that come into a police station for interviews voluntarily. Now, the overriding objective, I guess, from the national protocol seems to be that if an interview doesn't need to take place, then it certainly shouldn't, especially in this climate. So it's really working out the necessity of conducting these interviews and balancing that with equally a right to the defendant to put forward his account at the earliest opportunity. Same goes for voluntary interviews. I'd suggest that if there's no necessity for arrest and that's not met, then I would question the necessity to bring them into the police station to have that interview, especially during this current climate. But again, I write it there because I know from speaking to other solicitors that are doing police station work, clients are still asking them to attend police stations. I've put briefly on this side, I'm not going to go into a huge amount of detail because I'm sure we've not got appropriate adults here that are watching, but it's definitely a consideration. So whilst legal representatives and solicitors can now attend remotely for interviews, appropriate adults can't, and the PACE still applies to them. Now, handily, on the National Appropriate Adults Network, on their website, they set out 3 requirements that they need in order to be able to attend police stations physically. And they've said that if any of those requirements aren't met, then simply they will remove themselves from the situation. Now, obviously, if you're giving advice remotely over a telephone or from video, you're not necessarily going to be able to see if an appropriate adult is there. So I would just highlight that if you are conducting police station work, make sure that if you have concerns about your client and their vulnerabilities or whether they're a youth, make sure that somebody's there. And if you're able to, if you're there in the interview, so over video or something, just check that they are there. And if there's any concerns, just highlight it as you go through. Now, in terms of issues, now I know from several people that have attended police stations or indeed attempted to conduct interviews remotely, there are some issues that are being faced. So despite the national protocol coming into place on the 2nd of April this year, some officers are saying that they simply are not aware of the protocol and its existence of it. Now, if that happens and you are trying to get information and disclosure from an officer and they're saying, well, you need to come down to the police station to do so, make them aware of it. And if they're still not going to adhere to those protocols, then highlight it to the custody sergeant and make sure that you're making a note of all of these issues that you're encountering, because it's certainly a consideration when you get to trial. Now, if you've crossed that hurdle and they're aware of the protocol, there are still some issues. As we know in police stations, it's not got the best signal sometimes. So even though there are provisions to allow you to conduct an interview remotely and be there to give advice, sometimes signals on mobile phones simply don't work. So I would suggest that try and test the technology as best as you can. So if you can get through to the custody suite, which we know is one of the main issues when you're a representative, if you're able to get through, just make sure that they can hear you and you can hear the other end. And likewise, when you're in consultation with your client, if there are any problems, make sure you're flagging that up before you allow yourself to go straight into an interview, because what you don't want to do is get to a stage where an interview commences, you're trying to interject because a question's inappropriate or you have concerns, and nobody can see or hear you. Now, if that is followed, sometimes that means that an interview can be conducted fairly successfully, but we then have several options that police officers are now looking towards. So I've written here charge without interview. Now, if for whatever reason an interview is not able to take place during the pandemic, police officers are now, and as they always were, able to assess the level of evidence they've got and whether it's appropriate to proceed straight to a charge. That could be problematic because clearly your client's not been given an opportunity at this stage to put forward a defence. Clearly that's a matter that can be raised at the first appearance if it gets to that point, but I just think again that's another consideration and certainly a new consideration and something that's happening more frequently. The last thing that I want to touch on about issues is really if you have advised your client, for example, not to attend an interview or come out of his cell, for example, due to what we perceive as risks from the coronavirus pandemic, and we're not sure whether officers are adhering to the national protocol, officers still have the option to try and conduct a cell door interview. So just be alive to that fact and make sure that you're telling your clients, if you're able to consult with them on the phone, that even if they refuse to be interviewed and go into the interview room themselves, make sure that you advise them that that right to legal advice is ongoing. And if any officer tries to then ask questions about the offence, then they should simply say that they want to have you on the end of the phone and they're not going to engage in that conversation, because what we don't want to do is make them make admissions that they don't want to do. I've also put on here a missed opportunity for cautions. That really ties hand in hand with if an officer decides to charge without interview. Now, the problem with that is if there is overwhelming evidence, your client may not have been given an opportunity to admit to the offence, where ordinarily he may be entitled to a caution. So that's really something that we need to be considering when these matters go to court, to see whether we can revert it back to the police station, because clearly a caution is in your client's better interest than having a conviction against them. In terms of practical steps, really, like I said, I don't do police station work anymore, but I have had experience in it in the past. Just practical steps that you can take, really in relation to voluntary interviews. Make sure that if you have concerns about your client attending for a voluntary interview and you're yourself are questioning the necessity of this, make sure that you write some written representations down to the officer in the case. So sometimes you're able to get their email address. I would say if you can do written representations, that's always better because you've got it in a document, which can always be referred back to a court. And it just shows that you've raised these issues at the early outset and it's not just a trial issue. I've put there, make use of technology, do it as far as you can do. Clearly there are issues, there's teething problems that are happening, but just test it and make sure that you're highlighting any issues if it comes out. Now, I know that some firms of solicitors at the start of this pandemic were referring to what they called a standard coronavirus prepared statement, which I believe set out reasons why either they were advising their client to refuse to be interviewed, or indeed it was the client saying that they don't wish to be interviewed because of what they perceive as risks of the infection and potentially a fatal death really from contracting the coronavirus. What I would say with that is err on the side of caution. Now we've got this protocol in, there are other options that can take place instead of just reverting to a standard prepared statement. I've put there the possibility of just writing a prepared statement. If you're able to have a consultation with your client where you can ascertain maybe what they're saying in relation to the offence and highlighting a defence, you can give consideration to writing out a prepared statement yourself. And then at the start of the interview, there's nothing stopping you reading it out and asking your client to confirm that he's happy with what you've read and that he endorses it himself. So it's just the practical steps. Instead of getting a signature on a prepared statement, you can get them to endorse it orally, and then you can send that prepared statement to the officer at the conclusion of the interview. Now, if there are issues that arise and officers aren't following protocol, make sure that you're making a note of this, whether that's on the custody record or making or just making a note in your own booklet as you normally do so. Also be prepared to make a witness statement, because if this matter goes to trial, you just want to make sure that you've got a log of it. So that's really the practical considerations that I wanted to address today. So with that, I'll move on to Marie.
Thank you, Hannah, that was great. So this portion of the talk, you'll see I've highlighted 3 topics: abusive process, application to exclude evidence, and also adverse inferences. And all 3 of those are areas that may be relevant if following an interview, a case is charged and goes to trial. Really, there are a number of scenarios that I have in mind when dealing with these slides. The first is that your client has made admissions that they would not otherwise have done, and that they are not helpful to their case going forwards. The second is that they have made no comment, or the third is perhaps a mixture of the 2, but that there were other concerns, other breaches, for example, or technical issues that have hampered the fairness of the interview. Finally, of course, there may be things that you weren't aware of during the actual interview that come to light afterwards, particularly if you haven't met your client because you've only spoken to them on the telephone or attended in some other virtual way, and it turns out that in actual fact your client had comprehension difficulties or health concerns that weren't immediately obvious, but they would have been had you been in attendance. So let's start with abusive process then. There are 2 arguments that you can make for a stay on the grounds of an abusive process. The first is that it's impossible to give the accused a fair trial, and the second is that it would offend the court's sense of justice and propriety to be asked to try the accused in the particular circumstances of the case. Bear in mind that if you have a case at the magistrate's court, there isn't a jurisdiction to hear an argument under that second limb, and so the proceedings would need to be adjourned for you to make an application to the divisional court, and pending the outcome of their determination, the case would then go back to the magistrate's court to proceed. So dealing very briefly with that second limb argument, in the context that we're discussing, really my view, and others may disagree, is that you would really need a deliberate or willful disregard for the protocol on the part of the officers. Perhaps they are hoping to avoid the interference of a solicitor being able to give a defendant legal advice, because many officers have got the view that all they simply do is come up with ways for them to wheedle out of a slam dunk case, and don't necessarily have the respect that they ought to for the detained person's Article 6 rights. Even if you do have that sort of a scenario, of course, you're going to have to prove it. The burden rests on the defence, and it is on the balance of probabilities, but you're going to need to be able to introduce some evidence. So make sure, as Hannah said, you've made notes and you're prepared to give a witness statement if you've attended upon someone in the police station or virtually, and there have been problems. Limb 1, well, Article 6, of course, the right to legal advice, that extends to the police station, and if that has been withheld, there is a potential argument for an abusive process, but bear in mind that if there are compelling reasons, that can be one get-out clause for the prosecution, and arguably, or it may be argued by the prosecution that the compelling reasons are because they were unable to facilitate safely for the detained person to have access to legal advice. And even if that weren't the case, or that wasn't put forward, if the trial process is capable of dealing with any unfairness that has arisen as a result of the interview process, then an abusive process argument is unlikely to succeed. Well, that really quite neatly takes us on to the next section, which is applications to exclude. Just bear in mind that the slides are a little fuller than what I'm going into, but you will be able to access those slides later. So applications to exclude, there are 2 sections of the Police and Criminal Evidence Act that are relevant here. Section 76 deals specifically with confessions. So that first scenario, your client has made admissions in interview that he now resiles from, or he's made comments that are not helpful to his case. There are 2 conditions under which an application could be made under Section 76. That the confession was obtained under oppression, or that in consequence of anything said or done which was likely to render the confession unreliable, the confession is now unreliable. The burden of proof on an application under Section 76 is on the prosecution. So once you have raised it, it is for the prosecution to show beyond reasonable doubt that the confession was not obtained in those circumstances. And that's particularly interesting from a procedural point, but remember, you're going to need to have some foundation for that argument. I've made a comment on this slide that it's arguable, perhaps depending on the circumstances, that simply as a result of the COVID-19 pandemic, the detained person was under such a degree of stress and fear that they would simply have said anything to get out of there, or weren't thinking clearly and just wanted to get the interview over with as quickly as physically possible, in the hope that they'll be able to leave again. It's a matter for you to consider on a case-by-case basis. But in addition, the other considerations that I've mentioned may all play a part when taken in combination or separately. In terms of whether the confession is unreliable, for example, consider that it wasn't known at the time, that the interpreter or the legal advisor couldn't hear questions that were being asked and therefore couldn't intervene or interject, but it comes to light afterwards, and that could have rendered the confession unreliable. It may be that you need to make an application, or you need to introduce evidence on the voir dire, voir dire being, of course, almost a trial within a trial for the judge to determine an issue. And you can cross-examine officers about it, but also your client can give evidence on the voir dire, and that evidence is not automatically admissible in front of the jury. Likewise, the representative that attended or didn't attend the police station may also be able to give evidence. The best thing I thought about this section when considering this scenario is that even if you are unsuccessful, there is no barrier to you introducing this evidence again in front of the jury. The judge's decision is should the evidence be excluded, but if they decide that it shouldn't be excluded, that does not mean that the jury has to follow their determination of the facts. The jury is entitled to conclude that a confession was obtained under oppression or was obtained in circumstances that make it unreliable. And so even where a judge has ruled that it wasn't, they are still required then, if you've introduced that evidence again, to direct the jury that if they find that it was made in those circumstances, even if they were sure that the comments made in interview were true, they must disregard them because of the manner in which they were obtained. But I'll move quickly on to Section 78 because time is short and we did want to have time for questions at the end. Section 78, and I'm sure everybody is familiar with Section 78, it's a different question and there's nothing preventing you from arguing a Section 76 and Section 78 in the alternative. 78, the question is one of fairness, and I've set out the wording of the provision there on the slide. It's not the same question. If you have a no comment interview, of course, you wouldn't have been able to make an application under Section 76, and so 78 is where you're going to need to look. I've mentioned a case of Ibrahim at the bottom of this slide. Ibrahim is likely to be of particular relevance because it sets out a number of considerations where access to legal advice has been denied, or perhaps limited, arguably limited in these circumstances. The case refers to a number of conditions that may be helpful to a particular defendant. It refers to vulnerability, for example, or age. But one of the pointers that I imagine prosecutors are going to hang their hats upon is what directions can be given to the jury. If the prosecutor turns around to the judge and says, "Oh, but Your Honour can well deal with any potential unfairness arising from this by an appropriate direction to the jury," then that evidence is not going to be excluded. If we could move to the next slide then. I've set out, I kept repeating the point really that we need to know what happened at the police station. If your role is attending virtually or otherwise, then make a note. Often Section 78 arguments are made for breaches of the PACE codes, and it's certainly my view that there's an argument to say a breach of the protocol would have the same status. Clearly, it's something that needs to be tested and hasn't been yet, but I struggle to see how they would be treated any differently than a breach of Code C, particularly given its purpose. Remember, you don't need to establish any impropriety or bad faith on the part of the police. It may be that the officer in the case and the interviewing officers were doing everything they could to facilitate a fair interview. But if it wasn't a fair interview, through no fault of theirs, because the police station couldn't accommodate the provisions of the protocol, or there was a technological failure, if that's the case, it may not be their fault, but it still might be unfair. But don't be turned off from making an argument just because you haven't got any evidence of bad faith. And one last point, just to have a think about whether, if you are arguing under 78, whether you need to have a voir dire, because it may be that the circumstances that existed are not in dispute. It's simply the conclusion to be drawn as to whether or not it was unfair. And you might find that the prosecution are willing to introduce an admission to that as on that point. Section 34 then, we failed to exclude our interview, and now the prosecution has invited the judge to give a section 34 direction to the jury, or for the magistrates to hold an adverse inference against the client because of their failure to mention something during their interview. One point, Hannah of course mentioned that some solicitors have been advising clients to simply refuse to be interviewed. If a defendant was not interviewed and refused to be interviewed, there is no section 34 adverse inference that can be drawn, because that refusal was not a failure to answer questions, failure to provide those facts in the face of questioning. Just beware though that the venue of the interview doesn't matter so much if they decide to conduct it in the defendant's cell. A crucial point I've highlighted here, the circumstances which existed at the time. So that's an essential part of section 34. And of course, it's not to be construed restrictively. So the circumstances of the pandemic and the fears and the safety concerns that arise are all relevant factors, and there's nothing to say that they shouldn't be taken into consideration. If there has been an absolute denial of access to a solicitor, then section 34 again does not apply. An adverse inference cannot be drawn if the client has been refused access to a solicitor, and I'd suggest that that's even if it's it doesn't have to be deliberate. If, however, there has been legal advice, the reliance on legal advice as a reason for not answering questions, it does come with a special direction to the jury. But remember these 2 points. There needs to be some evidence that is why those questions were not answered. But also you need to be very careful about waiving privilege. If the client goes any further than that when giving evidence to suggest that the reason they answered no comment was because the solicitor said, and then recounts the advice that you've given, that would be waiving privilege in terms of that particular consultation, and it would then be open to questioning. However, I have also highlighted that in these particular circumstances that might not be a problem. Of course, your client might have said, I'm completely innocent, I've got an alibi, and at trial they're saying they've got an alibi, but you gave the advice, just answer no comment. Well, that's fine, there's nothing to risk really, but at the same time, it may be that your access to your client has been so limited that you've said, look, I can't give you proper advice right now. Let's not talk about it. Just get out of there as quickly as possible. And if that's the case, what is there to lose by waiving privilege in that limited way? Because the waiver of privilege does not extend to previous consultations or subsequent consultations. And again, I've made a comment about the appropriateness of giving evidence at trial by the solicitor or representative. If we could move to the next slide, then there I've set out a summary of the direction to the jury. I'm not going to go into great detail about it. It's on the slide, but it's of course worth bearing in mind that the judge doesn't have to give the adverse inference direction to the jury. Prosecution don't have to seek it either, but even if they have, the judge can say, no, I'm not going to give that direction. I don't think it would be appropriate in these circumstances. But even more helpful to the defence, you could seek to persuade the judge to direct the jury positively that they must not hold the no comment interview or the failure to mention those facts against your client. And judges will sometimes do this, for example, with a young defendant, where the judge is of the view, well, someone of that age, of course they're going to follow their solicitor's advice. But it may be that if you've highlighted all of the conditions and the concerns about the pandemic that existed at the time of the interview, then the judge will be persuaded to direct the jury not to hold it against them. And I think that's us in terms of those three areas, but I've just got a final slide about practical advice. Hannah has mentioned the importance of making notes and being prepared to draft a witness statement. But what if you inherit the client after interview, after charge? Maybe you're the duty solicitor at the magistrate's court, and this is the first time you have had any dealings with the client. Make sure that you take detailed instructions from your client as to what occurred and what legal advice they had access to. And if you then go on to instruct another advocate to do the trial, make sure you include that in the proof of evidence. Also be prepared to track down whoever did provide that representation at the police station, because again, we might need them to provide a witness statement. Raise the issues on the PET form at the first appearance or at the PTPH form at the Crown Court, so that it's clear that there is an issue regarding the admissibility of the interview. And I say that because that is then going to flag up that there will probably need to be statements taken, for example, from the custody sergeant, who would not ordinarily have provided a witness statement, and maybe the interviewing officers, if they're only dealing with the cases, I interviewed this person, and they have nothing more to do with it. You can, of course, always obtain the custody record, but it is important to have made your own contemporaneous notes of what happened at the police station, because I highly doubt that a custody sergeant is going to have added to the custody record, I told the defence solicitor over the phone that I didn't know about the protocol, or I didn't care about the protocol. So if something along those lines has happened, you're going to need more than just the custody record, but of course it's a good place to start. In terms of whoever's conducting the trial, make sure that they are aware of the protocol. Counsel in particular may not know about it, especially if they don't have anything to do with police stations. Make sure they know about it and also what happened at the police station, so that they can bear in mind whether there's any applications to make. And potentially you may want to positively instruct counsel to consider that point. And there's nothing stopping you making our very informative slides available to them if you think that would be of assistance. All right, well, we've only gone over by 4 minutes. Let's see if there are any questions. Hannah, has anything come through whilst I've been talking?
We've got one question there which says, remote interviews, are they a thing of the future? So, I mean, I guess I can try and tackle that one. I think certainly for now, whilst the coronavirus pandemic is on, national protocol still applies. So yes, remote interviews or remote advice, I guess, through interviews is something that's being actively encouraged. Whether that's something that the police want to adopt going forward once the coronavirus pandemic is over, potentially not. But it certainly shows that there is technology available. So maybe I'm quite dubious as to it, but we'll see. Just have a look. We've got another question here. Is the lack of an appropriate adult enough to render an interview inadmissible or unreliable?
Well, if I start on that, certainly in the past, pre-pandemic, there are authorities that say that if a person has got a legal representative present with them in interview, then the failure to also provide an appropriate adult is not fatal and doesn't necessarily mean that the evidence should be excluded. Of course, everything turns on a case-by-case basis. But it's certainly my view that things are different now, because if there's a difference between having the solicitor or representative in the interview room at the same time and them appearing virtually. If the solicitor is only on the phone, how are they expected to be able to flag up any concerns in terms of comprehension? Or if they're appearing on a video link, still it's not the same sort of level of interaction. So I'd suggest that you shouldn't be put off, I suppose, by the authorities that say that it is, you wouldn't necessarily exclude that evidence simply because there wasn't an appropriate adult. I'd suggest that, given that solicitors aren't physically attending the building, the failure to create an environment in which an appropriate adult can attend is of more concern. What do you think, Hannah?
I mean, piggybacking off of that, whilst the guidance is if a legal representative is there, then it may not render it unreliable. I would say that the roles of an appropriate adult and a legal representative are entirely different in nature. Obviously, legal representatives and solicitors are there for legal advice. An appropriate adult is there to make sure that they're understanding the questions and also that they're okay during the interview. So I guess it's a consideration, like what you said, if you're appearing virtually, it's going to be very difficult to be able to flag up any issues. So I would highlight the roles really between the two, and that's certainly a consideration, I would say.
Also the fact that there was a change, there was an amendment to Code C, or an update to Code C, I think in 2018, which made the separation of roles between appropriate adults and legal representatives very, very more it highlighted how distinct they are. They are not the same. They do not have the same responsibilities. And I haven't checked, but I don't believe that the authorities that I'm thinking of are so recent as to have taken into account those amendments to the code in the first place. We do have another question that I can see that is on a similar topic, and the question is, what advice would you give someone who suffers from a disability giving an interview, who suffers from Asperger's syndrome, as sometimes most appropriate adults who support are not qualified in Asperger's syndrome. Asperger's syndrome is an impairment on communication, verbal and non-verbal. Hannah, any thoughts on that?
I mean, obviously, it turns on a case by case and your involvement in speaking to that client. Always, I would say, if you've got any concerns as to your client's ability to be interviewed, then you need to be flagging that up. Don't just take it as read, and if there's an appropriate adult available, they're not there for mental health issues. They're there certainly to facilitate the interview. But if you've got an issue in terms of them being fit to be interviewed, then flag it up and make sure that they're assessed, because what you don't want to be doing is be in a position later on where they're then interviewed but realise that they really shouldn't have been. And you're right, the conditions are entirely different, they present differently. I'm not an expert in that regard, but I would say if there's any issues that you think could occur, make sure you're flagging it up every step of the way.
On that point as well, in terms of flagging it up, also make a note. You may feel that in those particular circumstances it's not appropriate for the interview to go ahead, and you might give that advice, or you might say, because of that, I'd advise you to say no comment, so that the interview is over as quickly as possible, and then we can deal with it later. And I hope that the 3 areas that I've just gone through might give you some idea of how that could be dealt with. Certainly, in that particular scenario, it would probably need a statement from the solicitor that's made that decision, and they may need to give evidence at court if there was a risk of an adverse inference, or there was an effort to exclude the interview. But it may be, in fact, that it's the sort of situation where you can raise it early with the prosecution, and a reasonable prosecutor, if they've got sufficient evidence in front of them, may well say, okay, we just won't deal with that part of the evidence. I'll agree not to introduce the interview, or not to rely upon it. It's more difficult if there's parts of the interview that are helpful to your client's case. But as Hannah said, everything is on a case by case basis. If anybody else has got any questions, then you can see on the slide in front of you that we've given the details for our clerks. If anything occurs to you after the webinar, feel free to email them and they will pass them on to us. At the moment, the only one of our clerks that can be contacted is John Francis. The other two, Lynn and Mike, who we love dearly, they're currently on furlough, but hopefully not for much longer. So please do contact John and he can forward on any inquiries that you have to us, and we'll do our best to answer you.